On the question of the standard by which we are to review the issue about confirmatory evidence, Ms. Wiebe, you say in your factum at paragraph 28 that the issue of whether evidence is capable of being confirmatory is a question of law and is to be reviewed on the standard of correctness. You will, however, agree with me that the statement on the standard of review is maybe a little more nuanced than that. True, if the evidence is not capable of being confirmatory evidence and the judge finds that it is, that would be an error in law and would be reviewed on the standard of correctness. However, when it is capable of being confirmatory and a trial judge so concludes, an appellate court should not interfere simply because it would have drawn a different conclusion on whether to bring that confirmatory evidence to the attention of the jury. Are we on the same page?
Yes, my lord.
Okay. In this case, the judge chose to tell the jury that certain evidence relating to motive was confirmatory of the evidence of the Vetrovic witness, who in this case is Jérôme Toupin. She also decided not to highlight the numerous other evidence that would confirm or support Toupin's evidence surrounding the horrible details of the murders, as well as the evidence of several experts regarding the manner of the death and the setting of the fire, finding that it would have been unfair to the accused to have done so. Ms. Wiebe, you can tell by my opening comments that the three of us view the critical issue on this appeal to be whether the evidence of the family members, specifically Nicole Labossière Clark and Daniel Labossière, whether that evidence is capable of being used as evidence confirming or supporting the evidence of the Vetrovic witness, who in this case is Jérôme Toupin. The accused argues that because the evidence of Nicole and Daniel was played to Toupin before he confessed to police, that their evidence became, quote unquote, tainted by connection, as referred to by Fish at paragraph 39 of the seminal case of Kayla, and therefore not sufficiently independent. There is no question that the evidence of the two family members, Nicole and Daniel, is credible and admissible evidence in the cause. The question is whether it's also capable of being used by the jury to give it comfort that Toupin may be telling the truth on that question. The judge in this case noted that there was no connection or collusion between Nicole and Daniel with the Vetrovic witness Toupin. She held that their evidence was from a source other than Toupin, and that their evidence was independent and therefore capable, potentially capable, committed error, and that that error is so significant that a new trial should be ordered. Did I get that right?
Yes, my lord.
Okay. I'm almost done. Ms. Wiebe, you advance as a rule of law the proposition that once it was established that the police told Toupin the evidence the other witnesses will say, before he gave a statement to the police, that that other evidence, the evidence of the family members, is now tainted by connection and therefore incapable of being used as confirmatory evidence. I have that right, I think.
You do.
So we want to hear you as well on that point, as well as on the curative proviso argument, which the Crown will also be addressing the court on that point as well. So at this point, Ms. Wiebe, the floor is yours.
Thank you, my lord. You've done an excellent summary of the case to the extent that some of my introductory remarks are somewhat redundant now, my lord, but you'll forgive me if I reiterate some of the comments that you've already made. I'll start by saying I think it's common ground among everyone that the case against Jérôme Labossière was almost entirely dependent on the evidence of Jérôme Toupin. Mm-hmm. That's a critical distinction that I intend to make throughout the course of my submissions, because this isn't a situation where there was ample other forensic or other available evidence, that especially direct evidence, that would have linked my client to these murders. The reality is that the evidence of Jérôme Toupin was central in this case, and it was the Crown's case essentially rise and fell with Jérôme Toupin. It was the issue in the trial. Again, it's common ground that Jérôme Toupin was what we call a Vetrovic witness in every sense of the word. I've outlined in paragraph 10 of my factum the concerns that the trial judge told the jury about.
Can you indicate if you're talking about your first factum or your second factum, please?
It's my first factum, I apologize.
So if you're referring to the second factum, you'll refer to it as your supplemental factum?
Supplementary factum, if I could.
Thank you.
Sorry, you said what paragraph?
Page 10, and it's paragraph 40. And I appreciate that it's a lengthy paragraph, but I think it bears repeating because the difficulties with Jeremy Tupen's evidence were massive. So if you look at, this is a summary at paragraph 40 of my factum. It's actually taken from the charge to the jury, which begins at page 151 of the appeal book, if that's of assistance. But to summarize the difficulties that the trial judge had with the evidence of Jeremy Tupen, I can say this. She indicated that he had admitted and planned to the planned, intentional, and cold-blooded killing of 3 people. He entered into an immunity agreement with the Crown to testify against the accused and the co-accused Michelle Hintz. As part of that agreement, in exchange for his testimony, the Crown will recommend that he be sentenced to life imprisonment with no chance of parole for 10 years rather than 25 years. He is critical to the Crown's case. He has admitted to being a drug mule, transferring multi-kilos of cocaine and large sums of money between Winnipeg and Vancouver. When he was originally arrested, he was interrogated for 5 hours without giving a statement. In that 5-hour period, police mentioned the name of the accused applicant, Jérôme Labossière, 57 times. It was apparent during cross-examination that he lied on many occasions and was often confused. Some of his evidence changed from the statement given to the police in 2008 to the statement given in 2010 and to his testimony in court. He testified that money was part of the motivation for the killings and that he and the co-accused were to be paid in 2 installments totaling $10,000. However, he initially told police that he had no idea how the payments were to be made and that the $5,000 that he put into his account at the time that he bought his house could have been from the profits of the drugs he was running. He insisted that he bought the house together with the co-accused, but the house was in his name alone, and he made all of the mortgage payments alone until he sold the house. His description of how he shot Remy Labossière, emptying his revolver into him until the chamber was empty from the front, is not consistent with the pathologist report that Remy Labossière was shot through the thigh from behind. There was some confusion as to whether or not there were any casings in the bag that was thrown away. Tupen was unclear as to whether the revolver he used could have had casings or not, and whether or not they would have been picked up. He indicated in his sworn statement to police in 2010 that he was not responsible for pouring gasoline around the farmhouse, but he admitted that he lit the gasoline. He only mentioned the co-accused in respect of the murder plans after it was revealed to him by police that the co-accused had referred to him as a psycho. And he was clear in his evidence that after the murders, his brother Andre picked him up in his black truck, but he could not explain a report from the East Side collision that showed that the truck was in the shop for repair from November 21st, 2005 until November 30th of 2005.
Ms. We've read your factum, and you're referring to essentially what the judge said when she was giving her Vetrovic warning. She says there were a number of areas, and I'm reading from page 22 or page 151 of the appeal book, page 22 of the transcript. She says there were a number of areas in Tupen's testimony that, in her view, would cause the members of the jury, would cause problems for the members of the jury in accepting his evidence. And she lists essentially what you're going through. And she lists, one, she says first, and then next. And I've counted, 11 or 12 reasons why the jury should be very, very cautious in believing anything that he says because of the number of inconsistencies, because he's a cold-blooded murderer, because he's signed a deal and he's got an immunity agreement for a lesser after pleading guilty to a lesser charge, and so she's gone through all of that in the context of her caution to the jury in the Vetrovic warning. Okay.
And the reason that I highlight this evidence, my lord, is because the case law has this running theme about the more central the Vetrovic witness's evidence is to the case and the more problematic it is, the more important it is that the charge with respect to the confirmatory evidence be correct and highlight what the jury needs to know about confirmatory evidence. I'm trying to make the point, if it is, albeit in a roundabout way, that there was a long way to go to restore any confidence in this witness's evidence.
I can't help to note a certain irony in this. In the draft charge that the judge gave to the members of the to counsel for comments before giving it to the jury, there was no reference in the charge about confirmatory evidence. None. And counsel for the accused, who was a different counsel than you, Ms. Wiebe, raised that point with the judge, and I'm reading from volume 9A, where he indicates you don't specifically point out in your charge, what could be confirmatory evidence. The judge responds saying, well, are you sure? Are you really sure you want me to start listing what all of the confirmatory evidence is? And counsel for the accused at the time of the trial says, well, as long as you add in, a line, which is now found, I believe the line that he asked be included, is now the central part, the critical issue on this appeal. And that's found at page 168 of the appeal book, page 39. The line that was added was, these comments attributed to Jérôme Labossière, if accepted by you, are evidence potentially confirmatory of Jérémy Toupin's testimony. So she also says, I could list pages of other evidence relating to Toupin's, relating to other evidence which would confirm what Toupin would say, but it would be so lengthy that it would be prejudicial to the accused to the point where it would make the trial unfair. Because what happened is the Crown caught the point that was raised by counsel for the accused at trial and said, you know what, that's a good point. You should include in it. Now, she does include only the parts which you're saying should not have been included. She doesn't include all of the other parts from the experts, all the gruesome details which confirm what Toupin was saying. And now I find it ironic that that's now the ground of appeal, the principal ground of appeal.
My lord, the details of that interaction that I think are particularly relevant is that it's Mr. Reutenberg on behalf of Mr. Hintz that indicates to the court you didn't provide any confirmatory evidence. It wasn't counsel for Mr. Labossière, and in fact...
That's not correct. No, Mr. Boursier actually raised it first. And then Mr. Reutenberg followed up with it later. But if you go to the I think the first pretrial conference after counsel have addressed the jury, I think you'll find it there.
Sorry, I misspoke, my lady. What I'm looking at is at volume 9A of the materials, page 7. And you're right, it is Mr. Boursier who says, and I'm looking at line 28. You do...
Page what?
Page 7, just the very end of line 28.
Right, so Mr. Boursier is the one who's raising it.
Well, but the way he says it is, you do mention at page 33 of the charge, however, my lady, that at the top of the page, that as you proceed to your instructions, you're going to point out what you believe may be confirmatory evidence. As I read through, or in my read of the remaining portions of, or actually the entire charge, you don't actually do that at any point. Point out what is corroborative of, and there's that exchange. And I think what Mr. Boursier is referring to there is, if you look at page 82 of the appeal book, which is the draft charge that was included in the materials.
Yes?
The very top paragraph, the trial judge says, as I proceed through my instructions, I will indicate where I believe there may be confirmatory evidence of Jeremy Tupen's testimony. So what Mr. Boursier, I say, is trying to point out there is that she makes this reference that she will point out confirmatory evidence and then doesn't.
Right.
And so he's just pointing out the inconsistency of the fact of saying I'll do this and then I didn't. But the trial judge, as you said, correctly points out, I'm not sure you want that in there.
Right.
And Mr. Boursier agrees with that he does not want that information included in the charge. But you're right, the Crown catches on to that and says, I think that we should include this. And the trial judge makes her determination as to what is appropriate to put in and what isn't. Now, I think of note there, it's important that, like you pointed out earlier, the trial judge has is owed considerable deference in terms of if she's legally right in saying the evidence is confirmatory, her decision whether or not to include it is subject to quite a bit of deference.
Out of discretion, yeah,
yes.
on her part.
And you note that the reason there that she doesn't include all of the technical evidence that you referred to, the gruesome details and stuff, is because in her opinion, or in her finding, that evidence is consistent and confirmatory of the fact that he was one of the killers. This is all information that he would have known as one of the killers, and so it doesn't necessarily lend any confirmation to the material and relevant aspects that I'm going to talk about later of his evidence, because there's a clear explanation as to why he would have that. It's not relevant to his testimony necessarily with respect to his position that Jérôme Labossière was actually involved. So I say that she was entitled to make that finding, and it was the proper finding to make in order to not prejudice the accused. But
My point, I'm not disagreeing with you. My point is just that it wasn't in the draft. It's now there in the draft, and now that becomes at the request of the accused, and it's now become the central issue on appeal.
Well, and the way that, counsel for the accused did say he didn't want it in there, and it was the Crown who actually persuaded the judge to put it in there. But part of this is, and I say this with all due respect to the trial judge, part of the difficulty is that it wasn't incorporated into the original charge, and so it seems like the sentence about confirmatory evidence was included in a section that wasn't meant to only summarize the confirmatory evidence. The heading, if you look in the draft charge, if I can just find that reference.
The part about counseling.
Yeah, page 94 of the appeal book. The heading for the evidence where all of this is summarized is, did Jérôme Labossière intend to persuade Jeremy Tupen or Michael Hentz or both to kill Remy Labossière? So that's the purpose of the summary of this evidence. That's the reason it was put together. And then probably because there was this request to put in the confirmatory evidence, the trial judge found that it was the most appropriate to put it in that section because that section encompassed the evidence of the family members. The difficulty is that it encompassed the evidence of all of the family members, and a lot of that evidence wasn't confirmatory in the sense that it wasn't material, and a lot of that evidence wasn't confirmatory in the sense that it was independent. And so all of that evidence is sort of painted with the same brush as potentially being confirmatory, and a lot of it isn't. And that gives the jury the impression that there's these mounds of evidence that is confirmatory of this very problematic witness's evidence, and that's a false impression that we say was left with the jury.
And again, I point out that who asked that it be put at that specific page? Mr. Boursier was very specific as to where it should be added, correct?
Well,
he indicated it should be, I would ask that at the end of page 49, or at the top of page 49, that you add, and that's where he indicated what should be added.
Sorry, could you tell me where you're referring?
I'm reading from page 8 of the transcript 9A. Volume 9A is what we refer to.
Right, but that's actually a point I wanted to make to exactly the contrary, my lord, because what happens is there's this discussion about including confirmatory evidence, and the judge says she'll include it. What Mr. Boursier asks for to be included at that specific section isn't the confirmatory reference or the reference to confirmatory evidence. What he says is at that section, and I'm looking at line 21 of page 8, I would ask that you point out that as with my point that during the interrogation of Jeremy Toupin, he was provided with the statements and played the statements of Nicole Labossière Clark and Dan Labossière prior to giving a statement, and I'm just wondering if your ladyship might be prepared to include that information again at this point. So he's not asking for the confirmatory comment to be put there. He's actually asking for the judge to highlight the potential for tainting. By virtue of the fact that the Vetrovic witness was played this evidence, the learned trial judge says that she'll consider that, but that doesn't actually come up in her actual jury charge. And one of the points that I'll make later on.
She does make reference to the fact that the tapes were played to the Vetrovic witness before he gave the statement on 2 different occasions.
She mentions...
Twice in her charge, she mentions that.
She says audio tapes were played. She doesn't mention which audio tapes or the significance of the argument with respect to the audio tapes whatsoever.
But she says, in fairness, she says that here are a number of problems with Toupin's testimony. Why you should have caution, great caution. You should be very cautious with respect to that. And one of the reasons is that the videotapes were played to him.
Yes.
That's why you should be cautious of what he's saying.
Right.
And when you read the charge as a whole, the Queen versus Jacquard, a Supreme Court of Canada decision, says that when you look at the charge as a whole, that includes the live issues at trial and the submissions of counsel and the closing address to the jury. In the closing address to the jury, it was made abundantly clear to the members of the jury what tapes we were talking about and why the concern with respect to Toupin's evidence on that point with respect to motive.
I
Correct?
would certainly concede that it was argued by counsel for Mr. Labossière in his closing, and he was cross-examined to that effect. That was certainly something that would be seen by the jury to have been a theme that was emerging. The difficulty that I have with that, my lord, is that the trial judge says this is one of the problems that you might have with this evidence. And it's sort of lumped in with this concept of he was examined or he was questioned for 5 hours and played audio tapes before he ever gave a statement. So in that sense, it's highlighted for the jury as being problematic. But there's never any reference to words like tainting or collusion or a specific reference to the fact that this evidence may not be particularly effective in helping them have some comfort with this individual's evidence, because the names of the evidence of the people whose audio tapes were played for the witness weren't even set. The jury didn't even have a reference between which witness's evidence we're talking about and the potential for taint. They didn't have the ability, I say, to make that connection, which is something that we say is critical. It wasn't highlighted for them in that way. There are 2 references to the fact that audio statements were played, but without highlighting those audio statements and their impact on Toupin's evidence, the jury isn't put in the position where they can assess whether that evidence is independent or not, and whether they want to rely on it or not.
Well, talking about assessment of the evidence, would you agree with me that at no point in time during the cross-examination of Toupin, with respect to the impact the playing of these audio tapes had on his testimony, he was never asked the question, what impact did these statements have on you with respect to the evidence that you gave?
No.
And that brings me to the rule of Dunn and Brown, where, in fairness, if you're going to be arguing that he had this evidence from his own, having heard the tapes, we don't know that because it was never put to him. Now you're arguing, it was argued as in the final address, and you're arguing now on appeal, but the question was never put to him squarely.
And my lord, I've actually summarized the evidence that, or the testimony that Toupin gave with respect to tapes he was shown and that sort of thing, and you're correct. There's a number of references to what he was shown, theories that were put to him, this sort of thing. I would say, in answer to your point, that it's immaterial whether he agreed or disagreed with respect to whether or not those had any impact on him. Because First of all, that would be a subject for argument at the end of the day. The suggestion has been made that he's adopted the fact that he saw this evidence. He clearly saw this evidence that lends itself to the ability to make the argument that his evidence has been tainted. But more importantly, when you look at the Sanderson case, you have a very analogous situation. On the facts of Sanderson, there was this whole issue with the couch, and the witness, the Vetrovec witness, said that he had been told by the accused that one of the deceased had managed to make it to the couch and had died on or in proximity to a couch. And this couch was a critical issue because the judge highlighted the fact that he knew this as being confirmatory of the Vetrovec witness's evidence. The difficulty was that same evidence was available from another source, that being the media, whether it was the Free Press or the Sun. And so the judge, this court in Sanderson, says in order to believe him that he got that information from the accused and not from the media, you have to believe him. So you're bootstrapping his credibility to his own credibility. And that just logically can't happen. So in this case, if he had said, I wasn't impacted at all by the fact that I was played these statements, everything I have is completely independent, you have to believe him on that point in order to then make the credibility findings that the Crown is asking you to make. You still have to bootstrap his credibility onto his own credibility. So even if he acknowledged, yes, I was completely influenced by that, do we believe that? Do we not? It's immaterial because the reality is that still depends on his own credibility, and that's just simply not something that can be done. His credibility has to come from independent sources. It can't come from his own assertions as to where he got the information from. So going back then to the evidence that the court highlighted, that the trial judge highlighted for the jury as being confirmatory. And I just wanted to take a step back and say that you referred to the seminal case of Kayla, which is at tab 1 of my book of authorities. And I've reproduced a quote from Kayla. At page 12 of my factum.
So what paragraph in Kayla are you on?
47.
I'm looking at paragraph 41 of my factum, page 12. It's a quote that I've reproduced from the Kayla case.
Which is paragraph 47 of Kayla.
And the court in Kayla talks about the dual purpose of giving the Vetrovec witness. Of giving the Vetrovec warning. It says a truly functional approach must take into account the dual purpose of the Vetrovec warning. First, to alert the jury to the danger of relying on unsupported evidence of unsavory witnesses, and to explain the reasons for special scrutiny of their testimony. The second, in appropriate cases, is to give the jury the tools necessary to identify the evidence capable of enhancing the trustworthiness of those witnesses. So the focus of that, or my point in reading you that quote, is to give the jury the tools necessary to identify the evidence capable of enhancing the trustworthiness. That's critical because, like I said earlier, because we say that the difficulties with the tainted evidence wasn't highlighted properly for the jury, they didn't have the tools necessary in order to evaluate that evidence and make a determination as to whether it was tainted or not. Kayla tells us...
Do you concede, Ms. Wiebe, that what I refer to as the Kayla 4, the 4 elements or the 4 characteristics of what should be typically in a Vetrovec warning were met in this case? And I draw your attention to paragraph 37 of Kayla, which sets out those 4. I think the Crown in their factum says, if I remember it correctly, that you appeared to have conceded that point.
I think she conceded the 4th point.
Okay.
I could just have one moment. Sorry, you said paragraph 37 of...
Yeah, paragraph 37 of Kayla has the 4, what's become known as a Kayla 4, the 4 characteristics or elements that should be in a Vetrovec warning?
Yes. The Kayla 4 are dealt with in the substance of the charge. The difficulty that we're alleging is essentially with step 4,
Right.
which is that the jury, in determining the veracity of the suspect evidence, should look for evidence from another source tending to show that the untrustworthy witness is telling the truth as to the guilt of the accused. And we say it's in the process of going through step 4 that the error occurred. And that's why you said there was some discrepancy with respect to the standard of review. That's why I highlighted that in Sanderson, it's made very clear that if evidence is held out to the jury as being capable of being confirmatory, and this court finds that it's not, that's an error
That's
in law.
not in law capable.
Right.
That is, yeah.
Right. And that's where we say the difficulty lies, is with step 4 of Kayla. Now, Kayla, again,
Do you have any authority, because we've gone through your factum, and we've gone through your book of authorities.
Yep.
Do you have any authority for the proposition that you're putting forward? Because what you're, and correct me if I'm wrong, but I think I got it correctly when I started off with my opening comments. Any evidence that the police tell a potential Petrovic witness, they tell him, here's the theory, here's why we know that this is the basis on which we come to this theory, because witness A, witness B, witness C said these things. We're even going to show you these statements, or we're going to play you these audio tapes, or make you see these videotapes. That whenever that's done, that then taints that evidence, and that evidence, while it could be admissible in court, cannot be used by the trial judge as confirmatory evidence to confirm the testimony of the Petrovic witness. It then precludes it forever from the judge from using that evidence as confirmatory evidence of the Petrovic witness. Is that your proposition? It seems that that's what it is.
my lord, that is one proposition that I would be asserting, but I don't even necessarily know that in this case the court has to go that far. Again, I'll make a reference to the Sanderson case, which is, I say similar factually, in the sense that you have a situation where there's a possibility of taint that's being advanced. There's the taint is that that the witness could have gotten the information from a source other than the source that he said he got it from, right?
And now, and I'm sorry to interrupt you, Ms. Wiebe, but now you're talking about the tainting of the Petrovic witness's evidence.
Yes.
You're not talking about the tainting of Nicole or Daniel's testimony, right? Their testimony, it's not tied to any collusion, to any interaction with the Petrovic witness. I don't think they even knew each other.
No.
Right?
No.
So when you're saying that the evidence is tainted, you're not talking about the tainting of the Petrovic, of Nicole and Daniel's evidence.
Right.
You're talking that as a result of the Petrovic witness being shown that before, it has tainted his evidence.
Well, the proper way to put it is to say that Nicole and Dan Labossiere's evidence, the confirmatory value of it was tainted by its association to the evidence of the Petrovic witness.
And do you have any authority for that proposition? Because Kayla actually is speaking, particularly in paragraph 39, to the reverse of that.
My lord, Kayla at 39 was actually what I would have stated as being supportive of that proposition. When I look at the third sentence in that paragraph, it says, where evidence is tainted by connection to the Petrovic witness, it cannot serve to confirm his or her testimony.
Right.
And that's the proposition that I'm making. The evidence of Nicole Labossiere-Clark and Dan Labossiere is tainted in the sense that it is connected to that of the Petrovic witness. I mean, it may be a reverse process in this situation, but when we're talking about collusion, tainting, all of these concepts, what you need to take away from it is always the same. The issue is there's no deliberate contamination of the evidence. There's no deliberate collusion between these two to match up their evidence.
Right.
But the reality is that when you're looking at confirmatory evidence, what you're looking for is basically to be able to get assurance that it's the truth because it's similar to other evidence that is potentially truthful. You're looking for that connection in order to satisfy yourself that there is some probative value or there is some truth to this evidence. When there's a suggestion, and I should note that's very similar to the similar fact rule. It's very similar in the sense that you're looking for connections between the evidence that are so similar that they provide the trier of fact with some comfort that the reason that they're so similar is because they're truthful and that it's not a coincidental sort of collaboration between the evidence. You look at similar fact, the minute that there's the possibility of taint, the possibility that the reason that that evidence is so similar is something other than the fact that it's truthful, the inference goes away.
Let's go back to paragraph 39 for a moment. In the last sentence, it says, where evidence is tainted by connection to the Vetrovic witness. Now, a plain reading of the section means, that sentence means where confirmatory evidence is tainted. And the cases that I've looked at and that have been provided all refer to, basically, most commonly refer to collusion. But there's no suggestion here of collusion between the confirmatory evidence and the Vetrovic witness.
I say with the greatest of respect, my lord, that there doesn't have to be deliberate collusion.
Right?
The reality is whether both parties colluded or not, the fact that the evidence may be similar for a reason other than the fact that it's true, that's the purpose of confirmatory evidence. And when you lose that, there's no value to the evidence.
My question, though, is have you got any authority, any case that supports this proposition that doesn't deal with collusion? Because in all of the cases that I've read, and that have been provided by counsel, it's a situation where there is a suggestion of collusion between the Vetrovic witness and the confirmatory evidence to be provided by other parties, or other witnesses, rather. Have you got any case where it isn't a situation involving collusion?
Well, my lord, I'll turn back again to the Sanderson case. The information was from the newspaper. It wasn't from a collusion with another witness.
Right.
It's the point that I'm trying to make is that it doesn't matter whether it's deliberate or not. As soon as the spectacle is raised that the information isn't reliable, well, the information isn't similar because it's reliable and it's the truth.
But the question is, what information is not reliable? You have here 6 family members who testified.
Yes.
They're completely independent of the Vetrovic witness, Mr. Tupan. They have no connection to him. So they have come and they have given evidence.
Right.
How is their evidence tainted? We start with the proposition that Mr. Tupan is an unsavory and unreliable witness.
Yes.
We move to, is there other evidence that can provide comfort to the trier of fact, in this case the jury, that would cause people, or cause the jury to believe that the Vetrovic witness is telling the truth?
Right.
If there's collusion, which is the common situation, then you can't say that the confirmatory evidence by those witnesses is, or you can argue in any event, it may not be of any value. But there's plenty of cases that say that's for the jury to decide.
They do. And that was the point I was trying to make earlier when I said that issue needs to be highlighted properly for the jury, and the jury is entitled to make that decision. That's why, my lord, when you asked me, do I need to say that that evidence is completely inadmissible or unusable as confirmatory evidence, that's the answer to that's the key to my response, and you don't have to go that far. The jury can make that determination, and this is that discussion of the proper tools. As long as it's highlighted for them, there's a potential taint to this evidence. You can decide whether you find it's tainted or not, and you can make the determination from there whether how little or how much of it you think is confirmatory based on whether you find that it's tainted or not.
You know, Ms. Wiebe, I think you've actually helped me a great deal with that. You are conceding that it can be confirmatory, provided the trial judge properly alerts the jury as to the dangers inherent in the proposed confirmatory evidence.
Well,
Am I right?
I think you can consider both scenarios. The law seems to be unclear on both, in the sense that...
But here, your initial submission to us is that if the trial judge had alluded to the confirmatory evidence and, in your submission, highlighted the dangers inherent in that evidence, there would be no complaint by you.
Well, I'll respond to that by saying this. In Sanderson, the trial judge actually highlighted for the jury that there had been cross-examination with respect to the media reports about the couch. That was not enough in Sanderson to say that that evidence wasn't tainted.
Right, but here we have 6 witnesses, two of whom are family members. The evidence before the jury was that some portion of the statements of those 2 family members had been played for Mr. Tupan.
Right.
But we have 4 other family members who give other evidence, arguably as to motive, that he was not aware of.
And that probably goes to the issue of whether the curative proviso is appropriate, whether perhaps there was enough other confirmatory evidence. But again, if you look to Sanderson, and what they say is when you have when this witness's evidence is the most central issue in the case, and the jury is left with the impression that there is more confirmatory evidence or stronger confirmatory evidence than what there actually is, how can you say that they didn't rely on that in terms of finding that this witness was credible? It's impossible to make that finding. And so even if there is some confirmatory evidence that was appropriate, because I'm not saying, and I actually am going to, in my arguments with respect to materiality, go through some of the evidence that was that I say was not or was material with respect to being confirmatory. There is some in there that could be confirmatory, and I would freely concede that. Mm-hmm. But the reality is that there is a lot that isn't, and the impression left with the jury was that there was this whole mound of confirmatory evidence, and in fact, we say that there was much less than what was actually left to the jury.
And then I need to come back to this point, just so I'm clear.
Yeah.
Had it been properly, in your submission, properly identified by the trial judge that there was this problem with at least the evidence of Nicole and Danielle, you would agree that it would be for the jury then to decide whether or not it was in fact confirmatory.
Well, again, my lord, there's 2 issues there.
Yes.
I think that Chief Justice was correct when he said that my starting position is that if evidence is clearly not independent, independence is one of the requirements of confirmatory evidence as laid out in Kayla. And if it's clear that this evidence is not independent as a result of association, tainting or association with the Vetrovec witness, it shouldn't even be put to the jury as a possibility.
You and I have been through that. Kayla, as I read it, talks about the tainting. Here, the suggestion is that the confirmatory evidence is tainted. And I don't see how that evidence has been tainted. It's as simple as that. It comes from 6 independent family members.
Right, but the 2 specific family members
Yes.
whose statements were played for the Vetrovec witness,
Right.
were then held out by the trial judge saying, I believe that this is evidence that could potentially be confirmatory.
Could be.
Could be, yes. And certainly, she says, that is for you to decide.
Right.
But this court makes that same point in Sanderson. In Sanderson, the court did the same thing, said, I believe that this is evidence that could be potentially confirmatory, but you still have the trial judge instructing the jury that she believes that this is evidence that could be confirmatory. And so I think, my lord, and please correct me if I'm wrong, I think that the difficulty that you're having with my submission is the relevance between the testimony of Nicole Labossière Clark and Dan Labossière and its link to the Vetrovec witness, Jeremy Tupan.
The problem I'm having is actually there's a looseness in what has been tainted. And we need to be kind of clear about that, because the cases talk about the evidence of the Vetrovec witness being tainted and looking for comfort in the confirmatory witness's evidence. And here your argument is that by virtue of the playing of the tapes, and I'll leave this in a moment, by virtue of playing the tapes to Mr. Tupan, that somehow or other the confirmatory evidence has become tainted. And I don't think that's what Fish says in paragraph 39 of Kayla. We can leave it. I make that point, though.
And, my lord, what I'll say to try to respond to that as clearly as I can is this. Confirmatory evidence exists to provide some solace to the trier of fact when the evidence is lacking in credibility.
Right.
So if I have a situation where a witness has said anything. They've said something, and the jury looks at it and goes, the only way they could have known that is if what they're saying is true. That provides them with that comfort. But if the witness got that from a completely alternate source, and you can prove that that alternate source was available to the witness, how can the fact that the independent and credible witness also said the same thing provide any comfort to the jury that that person is telling the truth?
Because the jury, I think, has to make an assessment of the credibility of the confirmatory witnesses. That's their role. They have to decide whether or not they're prepared to believe it provides the confirmation, which is why the trial judge said here, the evidence may or may not provide the confirmation that you require. Because there are at least two scenarios. One scenario is that Mr. Tupan was telling the truth, and the confirmatory witnesses were providing independent confirmatory evidence. The other option is that Mr. Tupan was not telling the truth, and that he tailored his evidence to conform with the confirmatory witnesses. That's why I think the trial judge says this may or may not provide confirmation and provide you with comfort.
And the may or may not provide, I would submit, is a reference as well to the fact that there's a vast array of other evidence that she said is confirmatory, and some of it is what I'll say is very loose, and the connection of it to the evidence of Jeremy Tupan is very tenuous at best. In fact, I'll give you one example later on where I will say that the evidence actually contradicted the evidence of Jeremy Tupan. But to me, that's the reference that the learned trial judge is making when she says, can you make that inference or not? That's for you to decide. But the theme, perhaps, maybe if I can put it this way to satisfy your concern, the difficulty that I have with this evidence is that both Nicole Labossière Clark and Daniel Labossière gave evidence with respect to the family farm. They gave evidence about specifically Jérôme Labossière being upset with the way that Remy Labossière was running the family farm. Nicole Labossière says in one of her statements that she had a very similar theory of what happened to someone named Brian Brisson. Brian Brisson's statement was also played for Tupan, and we say in those statements it was made very clear that the theory of Nicole Labossière Clark was that these murders were committed in order to gain control of the family farm. Well, Nicole Labossière Clark's evidence is about the will and about attempts to gain control of the family farm. There's this common thread that goes throughout that. So the jury, by having the evidence of these two witnesses highlighted for them as being potentially confirmatory, is possibly making the connection, oh, he said that it was to do with the farm. Well, they're confirming that evidence. I can confirm that he's telling the truth about that because other people also testified to that same fact. Except for if he got it from them in the first place, how does them saying it later on confirm his evidence? That's the difficulty.
Ms. Weeb, to be clear, we understand your argument. We're just saying, what's your authority in law on that? Because you'll agree with me, and I think my colleague, Justice Burnett, was trying to get you to say that in this case, the evidence of Nicole and Danielle was not tainted by collusion or collaboration or cooperation with the Vetrovic witness. There's no evidence of that. You agree with that?
I agree that it's credible evidence. The jury would have no difficulty finding it.
Right. So if we just look at that piece, that evidence is not tainted by collusion.
No.
It's not tainted by connection in the sense that they got that evidence from the Vetrovic witness. There's no evidence of that at all.
It's the exact opposite.
It's the exact opposite. And so, and where's the authority that says that this principle applies to the exact opposite? I guess that's what we're asking.
And maybe the best answer to that is you're the Court of Appeal and you're the people I hope will make that authority.
Okay. All right.
But my answer to that is that there's no suggestion that the evidence of Daniel and Nicole Labossière Clark was tainted, but the value of their evidence as being confirmatory is tainted by the fact that the witness knew it earlier.
We get your argument.
Okay.
We always got your argument. It was just show us where in law some authority on that, and we understand your point.
Well-
And just to finish off on that point, if it's clearly, your argument is that if it's clearly not independent, then it's not capable of being confirmatory evidence and would be an error in law to have done so.
Yes.
If your secondary position is that while it might be it might be tainted, it's still up to the jury to decide up to what point it's going to affect how they consider that with respect to the Vetrovic witness. Is that correct?
And then the responsibility falls on the trial judge to ensure that they have the tools to make that proper determination.
And in that secondary scenario is that you would urge the judge, you would have said that the judge should have in that situation added an additional instruction saying, be very careful with respect to that because that was played to the Vetrovic witness before, and it's possible that he tailored or made his evidence to conform with what he heard from the other witnesses.
Right. Either it shouldn't have been held out as being potentially confirmatory, or if it was going to be held out as being potentially confirmatory, the drawbacks to that or the potential taint of that should have been put to the jury at the same time. And that's the point I was trying to make with respect to the request that Mr. Boursier made on behalf of Mr. Labossière at the time. At the time when the judge was going through the evidence of motive and all of these comments by the family members, he specifically asked that the evidence of the fact that these two statements had been played to the witness be added in so that the jury could make that determination. And of course, like I said earlier, that wasn't done. The other thing I was thinking about while you've been asking me for authority is that the best reference I can make again is to the authority with respect to similar fact evidence. I think that there's a real analogy and a real parallel that can be drawn between the two in the sense that they both serve the same purpose, that is to provide comfort that there is truth to the evidence. And so if you look at the authority behind similar fact evidence, you'll see that the possibility of taint, the possibility of collusion really detracts from the ability for that evidence even to be put forward as being admissible in front of a jury.
And then you're referring us to the seminal case on similar fact evidence, which is tainted by collusion as the R versus Handy case, correct?
That's correct, my lord.
Any other case?
Not that I can think of a reference to at this exact moment. So moving away then from the independence aspect, we know that the other requirement of the evidence is that it be material in order to be potentially confirmatory. And I appreciate my hour is almost up, but I'll run through some examples of the evidence, and this isn't going to be the entirety of it because I simply don't have time to do that. But
And Ms. we have read, the material as you can see, all three of us very, very carefully. And so we have your written argument, but please go ahead if there are other points that you want to highlight for us.
Okay. Like I said earlier, we say that some of the evidence provided by family members could have potentially been viewed as confirmatory, albeit vaguely in our respectful submission. It's our position that the vast majority of this evidence was not capable of being confirmatory, because we know again from Kayla, we know from this court again in the Ponce decision that to be material evidence has to confirm a relevant and important part of the witness's evidence. Now, I'm not standing before you saying it has to confirm the inculpatory parts. That's very clearly not the law. But it has to be relevant and it has to be important. So trivial details, confirming that there was a McDonald's on the corner, that sort of thing is simply not going to suffice as being relevant and important parts of the witness's testimony. And if you look at some of the case law with respect to what satisfies as relevant and material, you look to the Grant case, the judge talks about the wiretaps, the body packs, it's not necessarily the actual incriminating evidence, but extremely relevant to very important parts of the witness's testimony. It's the same thing in Kayla. When you look at the evidence that's highlighted for the jury in this case, there's the suggestion that Jérôme Labossière told Gary Clark that Ramey was shot or should be shot for the way that he ran the farm, even though Gary Clark didn't take that comment seriously at the time. The fact that Remy Labossière was actually shot could maybe be viewed as potentially being confirmatory. It's a bit of a stretch, but at least that has some association to the Vetrovec witness's evidence. But the comment that was also
What paragraph are you on?
um,
So I can follow you.
sorry, I've outlined the section at paragraph 43 of my factum. It's actually all of pages 13 and 14. Those are the trial judge's instructions with respect to the potential confirmatory evidence. And you can see the first thing she talks about is Gary Clark. The reference that Gary Clark makes, or the statement that Gary Clark makes, that saying that Jérôme Labossière said they wouldn't be able to pin it on me anyway. How does that in any way tie to what Jeremy Toupin said? Like, there's not a real rational connection between those two pieces of evidence, and in fact, it certainly doesn't confirm a material and relevant, or a relevant and important part of Toupin's testimony. Similarly with the evidence of Nicole Labossière Clark, the comment that she testified to, that my client said it would be a bitch if the wrong person got convicted, that doesn't correlate in any way to Jeremy Toupin's evidence. I'm not saying that that's not a comment that could potentially be useful in the case as a whole, because it might indicate, it might be some sort of acknowledgement or admission on my client's part, and the Crown is free to argue that in front of the jury. But the issue here is, does it confirm Jeremy Toupin's evidence? And I say with the greatest respect that it doesn't. There's a really important distinction to be made between evidence that's relevant to the case and evidence that's relevant for the purposes of confirming a Vetrovec witness's evidence.
And we understand that. We understand that. Did counsel raise those concerns with the trial judge when she presented the draft charge?
Well, that the confirmatory statement, the statement about confirmatory evidence wasn't in the draft
Hadn't
charge.
been in yet, right.
So the first time he heard where she put it was when it was read to the jury.
Okay.
So
and
that's the difficulty.
Fair enough. Then after the charge was read, typically the judge says, is there anything that I misspoke? Did I misspeak? Is there something that needs clarification? Was that raised after?
I think Mr. Reutenberg raised it.
I believe that there was an objection made that Mr. Reutenberg added, and that, if it's the right part that I'm thinking about, that Mr. Boursier may have echoed.
With respect to the materiality of whether certain evidence can be confirmatory?
Certainly with respect to the nature of the confirmatory evidence that was provided.
I remember a comment he made with respect to adding a line about the statements being played before he gave his statement. Which
I'm looking, that portion of the transcript is at volume 10, beginning at page 60.
Volume 10. Okay.
And definitely Mr. Reutenberg is making a comment with respect to the use of the evidence that could only be made as against my client, I suppose, and not against his.
Right.
And he, at page 61, line 27, asks the court to consider mentioning the fact that the statement was played for Mr. Toupin before he gave his original statement. And it appears that's the extent of the discussion post-charge.
Thank you. So there was nothing?
No,
On that
not
point.
exactly on that point.
No.
It doesn't seem to be. One other piece of evidence very quickly that I wanted to highlight that the judge told the jury could potentially be confirmatory was the comment that was allegedly made to Dan Labossière that the parents were a surprise. That actually contradicts the evidence of Jeremy Toupin, because Toupin testified that it was actually Jérôme Labossière who came up with what he called Plan B, which was to kill everyone and burn down the house. And that exchange takes place at volume 6, page 35 of the transcript. But to summarize, Toupin testified that they told him they told him, that being Jérôme Labossière, that it was going to be impossible to make it look like a suicide and that they were going to have to kill everyone in the house. His evidence was that when they told him this, he accepted it and said, go ahead with it. So this notion that the parents were surprised directly contradicts what Tupen said, that he accepted it and that he said, go ahead with it, and that he was fully aware of it. So same point, that comment may have merit in the case proper in terms of some sort of admission that my client may be making, but it certainly does not lend any credibility to Mr. Tupen's evidence. In fact, it contradicts it. But yet this is held out by the trial judge as being potentially confirmatory, which I say is extremely difficult.
It seems to me, Ms. Wiebe, that in this case, the evidence has two aspects to it. The first aspect of the evidence from the family about the motive, it does two things. One, it's evidence of motive. So had Tupen said nothing about motive, had he said, I don't know why Labossière wanted me to do this, but he wanted me to do it. And if you'd had family talking about a motive, surely the motive, I guess my question is, would the motive not still have been circumstantial evidence that supported Tupen's relation, having tied Labossière into the murder? I mean, it's still circumstantial evidence that could give you some comfort that Labossière was involved because he had this motive. You see, it seems to me that the family, as I said, the family evidence has two aspects. One, if the family members say, Labossière told us that he was really mad at Remy because he was gambling and running the farm into the ground, and if Tupen says, Labossière told me that Remy was running up these debts and running the farm into the ground, the fact that Labossière told the two of them, if they were truly independent, would be confirmatory evidence. The family saying Jérôme told us this, and Tupen saying Jérôme told me the same thing. I think you would agree they would be independent if Tupen hadn't heard the tapes, and would be confirmatory just because he said the same thing. The second aspect of what the family says goes to motive, regardless of whether or not.
Do you agree with what Justice Beard just said?
I think if what you just said was that if the family had testified that about the motive, that being the desire to take over the farm.
Well, no. My point is, I think that this evidence has two aspects. One, if Jérôme had, if Tupen said Jérôme told me something other than motive, whatever and the family said Jérôme told them the same thing. The fact that Jérôme has said the same thing to each would give you some comfort that he probably said it. If he's repeating it to several people and there's no collusion, there's no tainting, then regardless of what the content of the statement is, the fact that he said it to two separate people would be independent evidence that would be confirmatory. Would you agree?
I would. And
Okay.
in fact, the only caveat I would add to that is what I said earlier about McDonald's. If it was motive or relevant and material evidence of
Right,
yes.
assuming that it was, but it wasn't motive, okay? So, and then if the family member, if Tupen had said, I have no idea what the motive is, but Labossière was involved and got me to do this, and the family provided evidence of motive, then that motive surely would still be supportive of Labossière's involvement, because it would be circumstantial evidence that would tend to support Tupen's evidence that Labossière was involved. Would you agree with that as well?
Well, I would say that the evidence of motive is relevant to the case as a whole, and that the jury could consider that when deliberating guilt or innocence. But does it actually confirm a material and relevant part of Tupen's evidence?
Well, Tupen,
I would say it doesn't.
I guess my question is, if Tupen says Labossière is involved, then does the fact that you've got evidence that Labossière had motive to be involved, does that not give you some comfort that what Tupen is saying is correct?
On a very basic level, perhaps. But again, I would say when you look at what is held out as being material, like in the Grant case.
But surely motive is pretty material. I mean, it's albeit not necessary. If you have evidence or strong evidence of motive, then that's pretty material, isn't it?
Well, and I'll refer back to the scenario you were giving me earlier, my lady. If the evidence of motive is there and it's consistent between the witnesses, then I say it would be potentially confirmatory. But the fact that,
But it would be confirmatory just because it was consistent. As I say, the issue of a consistent statement and motive, I think you have to sort of sort them out, because clearly the evidence of motive is admissible,
Yes.
whether there was any tainting or not. It's admissible just because it goes to motive.
Yes.
But my question is, and maybe you've answered this, but assuming that Tupence said nothing about motive, okay, but he's tied Labossière in, says, I don't know why he was there, but he gave me these instructions and I did it, and you've got independent evidence of motive, does that independent evidence of motive act as confirmatory evidence of Labossière's involvement?
my response to that, my lady, would be that I think that's a very difficult jump to make. What you have is, at best, evidence of motive gives the inference that this person had a reason to do this, at best. So without the Vetrovet witness saying this is why he did it, there's very little consistency between the two that would suffice to give any sort of comfort that this person is telling the truth. Just the very fact that he had motive to do it very vaguely might give some support, but when you're looking at the kind of difficulties that you had with evidence like Tupen's evidence, how far that would go in order to actually give that comfort, I say the value of that would be very, very little.
Are there other points that you need to make?
There was points that I was going to make with respect to the Crown's argument, just in order to distinguish the cases the Crown had relied on. What I'll say to sum it up, I have pages of notes on it, but I know the time is pressing. What I'll say on it is this. In those cases, and I'm talking about Boyce, Sumel, sorry. I would ask the court to look very carefully at the
Windmill?
And Windmill, look very carefully at the factual situations that you have there. You do not, in any of those cases, have a situation where the tainted evidence is actually held out by the trial judge as potentially being confirmatory. And that's a huge discrepancy. In all of those cases, the potential for taint was identified by the jury or to the jury, and the jury was told that it was up to them to make the determination as to whether that evidence was capable of being confirmatory or not. And I'll just point out that Windmill was relied on by the Crown in Sanderson, where the Crown made the same argument relying on Windmill as they do here, where they said that was for the jury to decide, it wasn't for the trial judge to say. And in Sanderson, very clearly that argument didn't work. The court said there was this taint, there wasn't the ability, that evidence was not even capable of being confirmatory, and so it shouldn't have been represented to the jury as such. Last point I'll make is that Sanderson is also very helpful on the issue of whether the curative proviso is appropriate if the court finds an error. If you look at Sanderson, I'll just refer you to the paragraphs. I won't read them to you because obviously you've read the case very carefully, but paragraphs 65, 68, and 72 are extremely instructive on the issue. Maybe I'll read you. 72, with everything in this case hanging on Stevenson's credibility and with there being absolutely no other evidence implicating the accused, the curative provision cannot be applied. It's a little bit different in the sense that there was other evidence essentially of motive in this case, but we know that motive alone is not enough to suffice for a conviction. I say with the greatest of respect that everything here hung on Tupen's credibility. It was the central issue in the case, and we cannot say what reliance the jury placed on the confirmatory evidence that was held out by the trial judge as being both material and independent. We don't know what they relied on and what they didn't. And so to speculate about that and to say they could have believed him in spite of all this extra evidence being given to them as being confirmatory that wasn't, is speculation, and that simply isn't appropriate. Those are my submissions, unless you have any further questions.
On your second ground.
Again.
Sorry.
So I just wanted to.
Yes, on the first one.
I have pages of that, but you know what? It is laid out in my factum. I'll leave my written submissions as a case.
Understood. My colleague, Justice Beard, has a question on the first one.
I just wanted to deal with the curative proviso for a minute. you would agree with, I guess I should, this is a question. The judge indicates in the pretrial conference that, and we've discussed this briefly here, that there was a significant amount of confirmatory evidence, albeit it went to the offense and not to Mr. Labossiere's involvement. Is that correct?
Yes.
Okay. And there was clearly a significant amount of evidence regarding Mr. Labossiere's motive. Is that correct as well? You would agree with me? Okay.
You mean from the family members? Or
From the family members?
Yes.
From apart from whatever Mr. Tupan said. It seems to me as well, if when you consider, although the trial judge doesn't, when she refers to the family members being confirmatory, talk about the fact that some of the information was given to Mr. Tupan in advance. She doesn't tell them that it might not be independent and that they're going to have to make that decision before they decide whether they can use it. She doesn't do all of that. But when you take a look at the trial as a whole, Mr. Tupan was cross-examined at some length about this, and he set out essentially what he heard and what statements were read to him. It was clearly set out in Mr. Bercier's argument that the tainting, and albeit not in connection with confirmatory evidence, it was referred to by the trial judge, the fact that he had heard this evidence. So when you take a look at the responsibility, our responsibility of determining whether the charge was functional or whether at the end of the day the error made any difference, I'm wondering whether there isn't enough there that you would have to say that this issue had to have been in the jury's mind. They had to have been aware of it.
2 points I would make in response to that, my lady. Certainly, I've already conceded that the argument was made by Mr. Boursier in his closing. But in reality, I would say with the greatest of respect, the jury treats the closing arguments of counsel very differently than they do the submissions of the directions that they receive from the trial judge. The jury is told that the trial judge is their instruction with respect to the law and how it's to be applied. And so I say that what they are looking for from the trial judge is confirmation, perhaps, that what defense counsel has told them they should consider is actually what they should consider. Now, going back to Sanderson at paragraph 65, and if you want to follow, that's at tab 3 of my book of authorities.
That's okay.
And on the issue, or what's relevant to the curative proviso, is what the court says. After the recharge, the jury retired to consider the matter, knowing that while they could believe Stevenson and thus convict the accused without any supportive evidence, it was nevertheless dangerous and risky to do so. I'll stop and say that's exactly the instruction that was given to the jury in this case. They could convict without the confirmatory evidence, but it was dangerous and risky to do so. They had been pointed in the direction of 2 matters which the judge said were capable of being supportive of Stevenson's credibility. It is obvious the jury might have considered those 2 matters in deciding whether to believe Stevenson. Certainly, I cannot conclude that they would not have done so. And that's the very point that I'm making here. There's a lot of evidence that was given to them as being confirmatory. The jury might well have relied on it, especially given that we say that there was a lot held out. There was this impression left that there were volumes of things that could be considered confirmatory when in fact they were not. So we say that it's obvious the jury could have or might have considered those matters when deciding whether or not to believe Tupan. Certainly, I cannot conclude that they would not have done so. In fact, I think it would be only natural and reasonable for a jury to seek to find some supportive evidence which would give them as high a comfort level as possible and which would reduce the danger and risk in believing Sanderson. There existed less of such evidence than the judge told them was the case. That's exactly what I say happened here. There was a lot less confirmatory evidence than what the judge told them was the case, and they might have relied on that in coming to their conclusions about Tupan. Thank you.
Thank you. I think we'll take the morning break. We'll return in 15 minutes or so. Thank you.